happy to be here. First time in Dubai, first time at the World Litigation Forum, and it's my pleasure to be here. So when I first started in arbitration, some years back now, I was told that arbitration is great because it gives the parties the freedom to tailor the proceedings as they need it, and because it's quicker and more, in some cases, more reliable than resorting to state courts, especially for cross-border disputes. Now, I've had the opportunity to work on a number of arbitration cases, having worked, as Natasha was saying, as an arbitration lawyer, both as counsel and as secretary to tribunals. And my feeling is that maybe arbitration has lost kind of its appeal. It's because mainly it's become a very complex dispute resolution mechanism in some cases. Technical disputes are handled by very highly specialized arbitrators and lawyers, which is good, but sometimes the procedures that you see that are agreed to are so complex that they become very time-consuming and very costly for the parties. Now, where do we stand today? This is the result of the 2015 International Arbitration Survey that was done by the Queen Mary University, and it points out that arbitration remains the preferred method of resolving cross-border disputes today, which is good news for arbitration. So 90% of the respondents to the survey consider that arbitration is their preferred way to resolve disputes. That's arbitration alone in 56% of the cases, and arbitration together with another alternative dispute resolution system as mediation, for example, for 34% of them. So why is arbitration so attractive? Easy enforcement of awards with the New York Convention, although I understand yesterday you touched upon the enforcement issues in the afternoon, so I won't get back to that. Neutrality. Choosing arbitration allows you to choose the seat of the arbitration, allows you to choose the law you want to apply to your disputes, and so you're in a position where you can avoid specific legal systems. Flexible procedure, which I was explaining just in the introduction, it's a positive thing, but you need to be aware of how complicated the proceedings can become. And mostly you can choose your arbitrator. This means that as a party, you should take this very seriously, appoint people who have the knowledge you need in your fields of dispute, and also people who are available to do the job. So generally, users are quite happy with the service provided to them, but the main criticism we hear today towards arbitration is the time needed to rule upon a dispute and the overall cost of the arbitration proceedings. What are the main challenges that we need to face today? The Queen Mary survey makes it clear that users are expecting arbitrators and the arbitration institutions to find appropriate tools to control time and costs in arbitration. Our main challenges today are that we need to be able to monitor the costs of the proceeding to make sure they remain reasonable. To ensure insight into the arbitrator's efficiency, this allows you afterwards to know best how to choose your arbitrator and have a trace of how well they do the job. And also time, guarantee expeditious proceedings. This is quite a subjective approach because what will be quick for simple cases will not be as easy to implement for more complex cases. So it's a case-by-case approach. This brings us to the two main issues I'd like to highlight with you today: time and cost in arbitration. Time. It's all about time today. We need to decide quickly. Business people need visibility as to the way forward in their business. But what is reasonable in terms of times? Various factors come into play: the number of parties in the arbitration proceedings, the subject matter of the dispute, whether you need to hear experts, whether you need to hear witnesses. All those elements have an impact on the time spent and the duration of the proceedings. But my feeling is that what matters most to the parties today is to know the time that will be needed for the arbitrators to provide their decision, to issue the award at the end of the proceedings. So how can the service providers and you, the users of the arbitration system, make sure that the job is done well and in a reasonable time? The parties. Choose well your arbitrators. You might think that a very known arbitrator is the best option for you, but maybe he's too busy. Maybe he doesn't have time or enough time to take the matter at hand and make sure things are done smoothly. There are young professionals out there who are very qualified and who you should be thinking about when you consider choosing your arbitrator. Choose the right counsel. An experienced counsel will know how to handle the proceedings in the best way for you. And a good counsel will know that a happy client comes back, so he doesn't have any interest in making things take too much time. He needs answers quickly to your questions. As a party, you should consider taking part in the drafting of the procedural timetable. This is one of the first steps once the arbitral tribunal is constituted, and a very important one. You know your case because you've brought it to your lawyer. You surely will have to discuss this with your counsel, but beware of the number of briefs you'll be agreeing to, the number, if there's document production, if there are experts to be called, because all of those will have great impact on the time you need to handle the dispute, and also at the end on the costs of the overall proceedings. Be involved in the process. That means knowing your case inside out from the beginning, and not leaving it to your outside counsel to deal on its own. And my advice would be to say that the parties should not forget that they have entrusted the arbitrators with the task to rule upon their disputes. They pay the arbitrators, they give them, there's a contract between them and the arbitrator for the arbitrator to rule upon their disputes. So there's nothing wrong during the proceedings at the end of it to ask your arbitrator when he thinks you'll be issuing the award. We often get phone calls from parties at the Secretariat asking us if we've heard anything about the arbitrator. We, of course, do a follow-up, and we make sure that things are done quickly, to as much as we can, but the parties are entitled to ask questions and to tell the arbitrator they're expecting something to happen and a decision to be issued in a reasonable time. And then avoid dilatory tactics. Of course, it's always appealing when you're a respondent, but in the end, it's a lot of time being wasted, and decision on cost might turn out quite painful for you. What can we do as arbitration institutions? Well, we can implement expedited procedures and emergency relief procedures. This is a trend today. We at the Swiss Chambers have an expedited procedure in our rules since 2012, which applies mandatorily for disputes under 1 million Swiss francs. It works quite well. We guarantee decisions in 6 months, so it's very appropriate for simple cases. And parties can also agree to it for higher amounts in disputes. It's something you should keep in mind. It's in rules of now major arbitration institutions. We can also consider including formal deadlines for the issuance of the awards in arbitration rules. Now, I think this works well if it's well managed by the arbitration institution, but I've seen, working as a counsel, cases where the award should have been rendered within 3 months after the hearing, which was the last step of the proceedings, and it turned out that 6 months later, nothing had been done yet. So I can imagine the arbitration institution at the time was sending emails and letters and giving phone calls, but then the arbitrator didn't move that quickly. Now, chasing the arbitrators, which is linked to the point I was just talking about, it works well, but depending on who the arbitrator is. Young ones will actually be eager to do the job in the required time, but more experienced one with a very a big agenda will tell you, yes, I'm doing my best, but you'll be waiting for some time. And now set up maybe cost structures to encourage efficiency and monitor the arbitrator costs and fees costly might be another idea. At Sky, we don't have that in the rules, but I can let you know that the practice of the court is when we come to the last steps of the proceedings and we see that nothing's really happening and the arbitrator comes to us and asks for an additional advance on costs, this is generally not agreed to by the courts. If no work has been done, it's considered to be extravagant request by the arbitrators. It might be an incentive for them to work better on another case. That brings us to the cost issue. We all have to monitor costs, and we're very aware of the need for our users to limit the costs and know in advance how much a proceeding is going to cost. So when we talk to costs, what are we talking about? Legal fees and expenses. This is the first and the most important cost item in the arbitration costs. Again, choose well your counsel. You might think that an experienced counsel is asking you an hourly rate that is outrageous, but in the end, if he does the job well, it's a good idea to go for the most expensive one. Because what I see today is that counsel who handle arbitration cases and do not have the experience come to us very often with questions. They do the same with the arbitrators, and in the end, it's a lot of time being wasted, and this is time that is being billed to the clients. Then we have the arbitrator's fees and expenses. These are determined generally if you go for institutional arbitration on the scale of fees that is set in the arbitration rules. You might want to have a look at those before you agree to certain arbitration institutions. I don't think there are better scales than others. It just depends on your needs. You need to assess that with your outside counsel. Now, to the best of my knowledge, there are no general surveys on how much these 2 points weight in the general balance of the arbitration costs. But what I can tell you is we've been looking at numbers at the Swiss chambers, and we realized that around 50% of the total arbitration costs are legal fees and expenses, and that the arbitrator's fees and costs weighs around 40% of the total arbitration costs. You don't agree with that? Maybe we can discuss it. Now, I mean, this is what we've seen from the cases we've seen in 2015. So it's not a general survey. It's what we've noticed in our practice. Now, cost of witness and expert. This also adds to the hearing cost because you generally have a hearing when you call witnesses and experts, and it does have an impact on general costs of the proceedings. And finally, the cost of the arbitration institution, which again will depending on the arbitration institution you agree on. But it's all set in the rules. Now, what can we do to monitor costs? Again, prepare your case ahead. Do not leave it all to your outside counsel. Choose well your counsel and the arbitration institution. I've worked on cases, on big cases when I was working with Lelive, where we used to receive boxes and CD-ROMs full of thousands of documents, and we as counsel were going through that and trying to figure out what had been going on. And I've seen other cases where the client came, met with us for a day, explained the whole situation, told us, this is what happened, I'll be sending you this and that, and this allows us to gain a lot of time and a lot of costs for our client in the end. And I think the cases were best handled because the outside counsel were not guessing what was to be done and trying to make up a case. Things were straight from the beginning. And when the insight from the business people of the clients, we had a clear view what needed to be done to best address their needs. Avoid hearings when they're when they're not absolutely necessary. Some arbitrators will automatically provide in the timetable that a hearing is to be held. But we see that some cases are very well handled on a documentary basis. So consider clearly, and specifically for your case, if you really need a hearing. And then monitor the arbitrator's fees and expenses. That's more for the arbitration institution to check. At the Swiss chambers, we check the costs very closely at the end of the proceeding, and the court agrees to the fees of the arbitrators. It's not unusual for the court to revise the fees lower than what the arbitrators are requesting, because having a look at how the proceedings were handled, the number of hours spent, and the general job done, sometimes they consider it's too expensive. As a conclusion, I would say that the parties should keep in mind that the proceedings are theirs. It's their case. They resort to arbitration because it's supposed to be a flexible dispute resolution mechanism. So they should be active in the proceedings. The proceedings need to be run in good faith with the view to reach an efficient dispute resolution process. And I think that if we keep this in mind, arbitration remains a very good tool to resolve cross-border disputes. Thank you very much. I'm happy to answer questions after my fellow colleagues have spoken. Thank you.